a small group so far, but maybe more people will trickle in. I'm going to just get started. So we're here to do a training on de facto parents today, and our goal is to give you a view from both sides, that being the side of when we have to represent de facto parents, when we're appointed to represent them, how you would attack a case from that angle, and also from the view of a parents' counsel who is maybe opposed to the appointment or granting of de facto parent status, or trying to foreclose or limit their participation in the proceedings. So we're going to hopefully give you a good angle from both those sides today.
How you doing? Good, thank you.
To begin with, just so you guys have a little bit of background, and it will kind of inform some of the objections or arguments that we make perhaps against the granting of de facto parent status. I'm going to take you through a little bit of a brief history of kind of how we got to this place. It's important to remember that the creation of de facto parent status is one of judicial construction. It exists nowhere in the statutes. In fact, I think de facto parent is, the phrase de facto parent is only referenced in 366.26 K when they talk about, or N, one of those, when they talk about one of the steps that a person can take towards receiving prospective adoptive parent status. They mention applying for de facto or seeking de facto parent status as one of those steps towards becoming a prospective adoptive parent. Nowhere else does it really appear in the statutory scheme. It appears in some of our California rules of court. That's where it's been sort of written down. But it was a creation of judicial construction, starting with In Re BG in 1974, so quite a ways back. And the judicial landscape at that time, this was pre-ASFA, so it was pre all these special requirements and information about caregiver notices and requirements for placement and assessment of relatives and caregivers for the best interest of the child. It was rare at that time for there to be an appointed minors counsel or guardians ad litem for children. So again, the court's in a place where at that time there weren't really anybody who had, maybe the county and maybe parents counsel, because as you note here, parents counsel was not even well established at that time. Parents were entitled to counsel in cases involving TPR, but only as a matter of statutory law. Due process was not always implicated, so they would look at it on a case-by-case basis and determine whether a due process issue was at stake, and would maybe appoint counsel for a parent only in a case involving TPR. As you know, Lassiter came 7 years after In Re BG. And then in all other proceedings, it was really just court rules and not a matter of statutory mandates. So you're dealing with a landscape where at that time, these parents, de facto parents, in Re BG, who had been caring for this child since birth, when mother left the child in their care to go to Czechoslovakia, were essentially the only person who could speak on behalf of this child, who had an interest in the care and companionship of this child. It's also important to note that I've realized that, sometimes de facto parent status has been used as an alternative for where, before we had a third presumed parent statute, maybe a step-parent who might otherwise qualify as now a third presumed parent was seeking de facto parent status to have an opportunity to somehow participate in the proceedings. So a lot has changed since the creation of it, which somewhat informs why you might be arguing against, if you were parents' counsel, its necessity in any particular case that you might have before the court, given alternative means or mechanisms or ways for these individuals to now participate, for the child's interests to be asserted. So that is that. These are just some quotes from In Re BG and giving you sort of the very inception of this. it talks about how the fact of biological parenthood may incline an adult to feel a strong concern for the welfare of his or her child, but it is not an essential condition. So they said a person who assumes the role of a parent raising the child in his or her own home may in time acquire an interest in the companionship, care, custody, and management of that child. So if that language sounds familiar, it's because that's essentially what they pulled and placed into the rule of court, creating the definition of a de facto parent. They went further to say de facto parents such as foster parents. So there is no way for us to say that a foster parent can't be a de facto parent, which we all very well know because that happens all the time, should be permitted to appear as parties in juvenile court proceedings to assert and protect their own interest in the companionship, care, custody, and management of the child involved. Now remember, this is with the background that I just discussed, where there were not alternative means, which we're going to discuss with you a little bit later to explain why maybe the necessity doesn't hold as true today. So the definition, straight out of the rules of court: person who has been found by the court to have assumed on a day-to-day basis the role of a parent, fulfilling both the child's physical and psychological needs for care and affection, and has assumed that role for a substantial period of time. Now we're going to go through those elements and factors in more detail a little later, but there's a number of issues there that the court's going to consider. To start with, it must be an adult, because we're talking about a parent, a de facto parent. So it does need to be an adult. We're not talking about a minor sibling or something to that effect. There is no contemporaneous requirement. It need not be the current or immediately succeeding caregiver for the child. So you'll see in some cases I've had before where you might have grandparents who maybe the petition came in with the child in the care of mom or dad, but grandparents maybe for a period of time a couple years ago were caring for this child on a day-to-day basis. There is no requirement that it needs to be immediately prior to the filing of the petition. Doesn't need to be that current caregiver. So I have had courts grant that status to a grandparent who was maybe a previous caregiver upon a sufficient showing that they met the factors required that we'll discuss a little bit later. Now, as you'll see, that should require some specific knowledge, and they should still have current information about the child's interests, well-being, maybe needs, both psychological and physical. But just because they're not the caregiver, as long as they've maintained a role in their life, they may be able to establish that, combined with the fact that they've assumed the role at some point. And just a note here, which we'll get into a lot more as well when we go into detail, is that it does include this provision that it has to be for a substantial period of time. But what is a substantial period of time? It's not clear. It's not really defined anywhere. So that's going to be something that gives you room for argument. I mean, I may argue that at least 6 months, a period of reunification, probably it would need to be at least that time maybe for it to be a substantial period of time at the very minimum. But there is no requirement. The court can make that finding as long as they define it to be a substantial period of time in consideration of all the factors that they're going to look at for granting or denying de facto parent status. So how is it obtained? The procedure is a written request, and it's going to be on the 3 forms noted there. The 295 is the request that names the person who wants it and forms the basis of the request. The 296 is their statement in support of their de facto parent request. So that's where the person is going to include information about whether they've attended court proceedings, the information that they may have unique to their care of the child about the child's medical, educational, dental, emotional, psychological needs. They're going to include information there about the time frame that they've cared for this child and how they've been actively involved in this child's life. So that's the statement. And then there's the 297, that's the order. So that's where the court, the order actually provides for sort of like a 388. It has a grant, deny, or set a hearing to hear. So at the order form, the 297 does actually provide for the court to potentially be able to do it ex parte, it appears. But generally speaking, as you'll see, we're going to talk about how you should be asking for proper notice and an opportunity to be heard on that issue. If your parents' counsel and your client may have a reasonable and legally based opposition to it. Timing, there's a typo in the slide, my bad. It is actually California Rules of Court 5.534A. It was formerly enumerated E, so I mistakenly left in the formerly lettered rule of court. So it is A, but it defines it as the court may give a person status at any time at or after disposition. So this should not be an issue that comes up at detention or adjudication. And if it does, you should be telling the court that it is not ripe for consideration. Per the rules of court, it can be considered at or after disposition. That does mean that potentially the court could grant de facto parent status prior to hearing the contested dispositional issues, like concurrent with the disposition hearing. As parents' counsel, we may often be trying to delay that beyond, especially if you're trying to get like home a parent or something and you don't want this person to be participating and maybe be objecting to or cross-examining witnesses or participating in terms of presenting evidence against your client. But it does say by statute at or after disposition. And it should be properly noticed. So the burden of proof is preponderance of the evidence. That's by case law. Pretty standard. There's no real dispute there. And from case law as well, as you probably all well know, if you've had a de facto parent request that you've tried to object to, the courts will very often cite case law. I think it's both Rachel C. and Leticia S., I think, but it's ordinarily liberally granted on the theory that a court can only benefit from having all relevant information as to the best interests of the child. And if the information's not helpful, then the court can just choose to give it the weight it's deserved. You know how many times do you hear the court admit evidence and say, over county counsel's objection, I'll admit this letter and give it its due weight, or consider it appropriately. That's kind of what the courts are saying here, that we should probably just let them participate and give their position and information to the court, and then the court can be like, well, they're really clearly biased, they want to adopt this child, or can make assessments about how relevant and pertinent the information is that they have to provide.
So, when the court is considering making or granting an application for de facto parent status, the court is instructed to use a totality of the circumstances approach to whether or not it's appropriate or not. And the determination will depend strongly on the particular individual seeking the status and on the unique circumstances of the case. Prior to Patricia L., there were several cases that identified factors that were relevant to the determination of whether or not to grant de facto parent status. And what Patricia L. did was it sort of culled from those cases a list of factors that are relevant to the determination. And that list is on the slide. One of the factors is whether or not the child has psychologically bonded with the applicant. So when you're thinking of these factors, you want to be considering, I mean, many times as parents' counsel, we're in opposition to the court granting de facto parent status. So when you consider these factors, you want to look at it, well, how can I argue, you know, that there's no evidence to suggest that the child is psychologically bonded to the applicant. Whether or not the applicant has acted as a parent on a day-to-day basis for a substantial period of time. key being here, substantial period of time. Many times the applicants are foster parents, so they will be caring for or they will be assuming the role of the parent on a day-to-day basis. But the case law is silent as to what a substantial period of time is. So we want to use that to our benefit and argue it has not been a substantial period of time. The child is 10 years old, but has only been living with the foster parent for 1 year. That's not a substantial period of time. Whether or not the applicant has information about the child that other parties in the case cannot provide. This is key, right? The court has the information from the social workers, from the therapists, from the minor's attorneys. There's nothing unique about this person who is seeking de facto parent status. No information that is unique that they can provide. There's no reason to grant this person de facto parent status. The report has all the information that this person is offering. Whether or not the applicant has regularly attended juvenile court hearings, right? A lot of times the caregivers don't come and haven't been there. So we can argue they're not really informed about the process. They haven't been here on a regular basis as another basis to deny the application. Whether or not the dependency proceeding might result in an order permanently ending contact between the applicant and the child, or result in the applicant losing custody for the child. You know, you may be able to argue that we're at the stage in the proceeding that we're at, Your Honor, no one is requesting that the child be removed from the caretaker. Therefore, the issue of the child's status with the caretaker is not relevant at this time. If it becomes relevant, the court could order de facto parent status at that time, but there's no basis to order it at this time because the court is not considering an order removing custody from the applicant. To kind of piggyback on the last slide, what objections can be made to the court granting de facto parent status or an application for de facto parent status? First one, obviously lack of proper notice. All parties have to receive standard notice requirements. The failure to meet the requirements that we just discussed on the prior slide. So all those factors you can use as an argument, as crafting an argument as to why de facto status, parent status shouldn't be granted. Misconduct of the person who is filing for de facto parent status. So in the next slide we're going to talk about automatic denial of de facto parent status. I'll save that conversation for the next slide. So, equity argument. So, what is an equity argument, and how can we use that sort of in a way to convince the court to not grant de facto parent status? So, the factors in the prior slide are important, but they're not necessarily dispositive. The de facto parent status is a privilege. It's not a statutory right. So the courts have substantial latitude in whether or not to grant or deny such motions. And one of the best ways that I think that we can defeat these motions or these applications is through an equity argument. So we've learned that the court's going to look at a totality of the circumstances of approach to determine whether or not to grant the application. So a totality of the circumstances approach will include the procedural posture of the case, so where we're at in the proceedings, and the expected positions of the parties already involved in the litigation. So I'm going to give you an example of an equity argument, okay? In this case, Your Honor, the court should not grant de facto parent status to the applicant, even though that they may meet the statutory, or not the statute, the criteria listed in the cases or in the California Rules of Court. Because in this case, reunification is a realistic possibility. and my client opposes granting de facto parent status because the foster parent clearly opposes reunification with my client. So granting de facto parent status to the foster parent will impose an additional and perhaps unfair burden to my client who is struggling to overcome personal issues and reunify, and is likely to make the case more adversarial. Okay? This is the type of argument that we can craft in trying to convince the court for an applicant that basically meets all those criteria, how we can try to convince the court to not grant status. Key words there are adversarial. These courts, they don't need any more conflict, right? We're in reunification. Reunification is a possibility. There's no necessity at this time. So all those types of arguments will be equitable considerations that the court may listen to and may actually find dispositive as to why the court should not grant de facto parent status to an applicant that may ordinarily qualify. So, caregiver misconduct. So, this is kind of a limited circumstance, but basically, again, because de facto parent status is a privilege derived from the assumption of assuming parental duties for caring a child rather than a statutory or constitutional right, the applicant may be precluded from de facto parent status simply due to their own misconduct. In Keisha E., the Supreme Court held that a non-parent or an individual who had sexually abused a child had forfeited the opportunity to attain de facto parent status. There's another case, Letitia S., and the Court of Appeal in that case adopted an expansive interpretation of Keisha E., concluding that the juvenile court had abused its discretion in granting de facto parent status to an applicant whose drug use and physical abuse of the child constituted the basis for juvenile court jurisdiction. Boil it all down. If an applicant for de facto parent status is the cause as to the dependency proceedings, the application has to be denied. Okay.
Jason, I'm
Yes.
sorry, before you move on, can you address the not applicable at Section 387 petition?
Yes, please.
So now we said the caregiver misconduct is going to be a bar to the grant of a de facto parent status. However, case law has said that this doesn't apply at a Section 387 petition, such as in Re Jonique W. While I will say, I'll just make a comment, I think in that case, I think there's still an argument that even if it's at a 387, that you can make the argument to deny the status based on caregiver misconduct. I think the court liked that caregiver in that case and thought it was a BS petition that shouldn't have been sustained against that caregiver, and ultimately dismissed I think they reversed the findings sustaining the petition. So I think that was what that caregiver had going for them in that case, but they did say that because a 387 isn't the cause that brought about the dependency case. That case was brought about from that original 300 petition. A 387 is a request to remove a child because a disposition is ineffective at that point, right? So it is essentially addressing head-on one of those factors, which is that a caregiver may be permanently disclosed from future contact with that child. So that's kind of the analysis that they undertake when it refers to 387s. But I will say that case is very distinguishable. So if you are adverse, and it is foster parents, foster parents wouldn't really have a 387 necessarily. But like it's a relative who your client's very much adverse to. Or maybe it's a paternal relative and you have mom and they are not getting along. This case is distinguishable. The conduct in this case was really not that bad. It was a bunch of general neglect allegations, no actual, like you talk about in Keisha E., that's sexual abuse. That's pretty clearly bad malconduct that contravenes the role of a parent. And then when you talk about Letitia S., even though it extends it from abuse to abuse and neglect, there was still physical abuse in that case, in addition to the drug usage, which constituted neglect. So, and then you get to Joni W., which is just general neglect issues in terms of being able to meet the children's needs with their special behavioral issues. There were also some issues in that case with there being no alternative. Like, this was one caregiver who was stepping up and available to, you know, provide permanency and be there for these kids. And taking that away, there weren't, you know, really other alternatives. So it's distinguishable if it serves you. It's also, if you want to be arguing for, maybe your client really doesn't want the child removed from that relative at that stage in the proceedings. Maybe they're aligned with that relative. So you want to be arguing for that relative to have de facto parent status so that you guys can, maybe they can get an attorney and you guys can tag team the 387. There's also, you could argue, aligned with the facts in that case that, you know, there shouldn't be a disqualification due to caregiver misconduct when we're not at a 300, we're at a dispositional failure issue under a 387. Does that kind of make sense? Yes? Okay.
So, alternatives to de facto parent status. So you should consider also making the argument that de facto parent status, which enables a person to fully participate in the hearings, is not necessary, and that the individual has alternatives to participate on a limited basis in the proceeding. Two ways of doing that. One would obviously be a 388. So, you know, the same type of arguments, Your Honor. If we're in reunification, you know, my client opposes the application for X, Y, and Z. It's likely to make the case more adversarial. The person opposes the child reunifying with my client. And this person also has the ability, if necessary, to file a 388 and petition the court to change or modify or set aside any order that they believe is made in it that is adverse to them, right? Because they are not a parent, but they are a person having an interest in the child. So if the court were ever to make an order or contemplate an order that was adverse to them, they could certainly file a 388. Another way that they may be able to participate on a limited basis is, Your Honor, if they're concerned about the court having complete information, they're certainly able to protest or request to participate as a relative pursuant to court rules 5.534B. This would give the person the right to submit information about the child to the court at any time. They could submit the information using the relative information sheet, or they could provide a letter to the court. But if the basis for why the person is requesting de facto parent status is to provide information to the court, there's another mechanism in which the court can authorize that. Again, reminding the court that there are other alternatives to simply granting a person de facto parent status, which allows them to participate in the proceedings and gives them procedural rights, possibly would convince the court to deny the application but allow them to simply submit relative information sheets, or again to petition the court via 388 vehicle.
And there was one other alternative that we kind of left off this slide, but that's also important. We mentioned relatives in a 388, but there's also the caregiver participation under Rule of Court 5.534K, which obligates the department to provide all caregivers with notice of the proceedings, notice of the recommendation, what's going to occur. It gives them a right to be present, to be heard in that proceeding. The comments to the rule of court talk about how courts should, the idea is that caregivers might have information or interest in the child that could benefit the court in making a fair determination an adequate assessment of the child's best interest. So the comments say the court should allow caregivers to speak up, you know, in the middle of these proceedings. If they have something to say and they want to let the court know, that they should liberally allow these JV 290s, the caregiver information form, to be filed, even if it doesn't strictly adhere to the requirements, the filing requirements included in the statute. So there's this other alternative that totally protects their right to be heard and provide information to the court. So in line with the other alternatives that we mentioned.
So if the court grants the application for de facto parent status, it's important to understand what that actually means and what a de facto parent status can then, or what a de facto parent can then do. So the California Rules of Court state that a de facto parent may be present at the hearing, may be represented by counsel, and may present evidence. De facto parent status provides what are procedural rights, but it doesn't confer any substantive rights. For instance, parents have due process rights, they have a presumption to the custody of their children unless it's shown that parental custody would pose some sort of risk or detriment to the child. In contrast, a de facto parent only has the right to persuade the court, the ability to try to persuade the court that what they want is in the child's best interest. They don't have any constitutional right to the care of the child. In addition, and we're going to go through them, but the procedural rights that are afforded to the de facto parent are less extensive than the procedural rights that are afforded to parents or children or guardians. Yes?
My understanding is the de facto parent is not allowed to get a copy of the report.
So we're going to talk about that.
Okay.
Yeah. So the court, the California Rules of Court sort of list, and you can use this to your advantage if you're seeking to limit a de facto parent from doing something. So the California Rules of Court specify that children, parents, and guardians have the right to cross-examine witnesses, have the right to use court process to subpoena the attendance of witnesses to court or obtain documents. They can receive all documents filed with the court, and they can inspect all documents. So that's what the California Rules of Court say that parents and guardians and children do. So there's an argument that if a de facto parent wants to do one of those things that is not explicitly listed in the California Rules of Court and was explicitly listed that what parents can do, that you can argue, well, the legislature, Your Honor, if they intended that the de facto parent have the ability to receive the reports, they would have listed it in the California Rules of Court like they did for parents. If they want to cross-examine witnesses. Now, we're going to see that it's not always so cut and dry, but I'm just advising you of arguments that you can make as to if you're trying to limit the de facto parent from doing something that you believe will have an adverse effect on your client. And that's why we put, did I put it? Maybe I did. No, it's okay. So you should basically be aware that the court has the discretion to grant a de facto parent the right to do something that isn't specifically listed in 5.534A. And there's some cases that talk about, there's a Matthew P. case that says the court shouldn't have considered the social worker's report without giving de facto parent status as an opportunity to cross-examine the social worker. But then there's also cases such as Damien B., which said that the juvenile court's denial of the de facto parent's request to call and cross-examine witnesses was not prejudicial error. So again, the court has pretty much wide latitude to grant or deny certain things that are not explicitly listed in the California Rules of Court, but it shouldn't prevent you from arguing that the de facto parent has no right to the report. The de facto parent has no right to cross-examine witnesses. The de facto parent doesn't have the right to subpoena some document, et cetera, et cetera. You want to jump in?
Sure. So the next kind of series of slides, for the most part, we kind of framed as like a back and forth, a comparison and contrast between de facto parent rights, or if you're, you know, in a situation where you're being asked to represent a de facto parent versus in a situation where you represent a parent. And for the most part, the stuff we put here is assuming that you're representing a parent who's adverse to the grant of de facto parent status. If you're in agreement with it, then just jump on the de facto parent side and start arguing those rules and statutes, or case law, sorry, rules and case law. So, as Jason already talked about, the procedural due process rights are quite more limited with reference to de facto parents than what is delineated in the rules of court for parents. So you're looking at a comparison of 5.534A versus G for parents. And you really are going to be making the argument that, like he said, the legislature knows what they're doing when they're writing these things, or the Judicial Council knows what they're doing when they're writing up these rules of court. And if they had meant for them to be exactly the same, why would they have not just put them together and or duplicate, made the rights duplicative? So from the de facto parents' standpoint, they do have the right to be present. They do have that right to counsel, but it is only at the discretion of the court for court-appointed counsel. So we do not have to be appointed for any de facto parent who is granted status, whether or not they have a private counsel. The court is supposed to, but this is something that is over my head, is supposed to do the indigency analysis, but they, don't. But bottom line is, case law says they don't have that same constitutionally protected right to counsel that our clients do under 317, because they don't have substantive due process rights or constitutional rights at issue, which we'll get to on the next slide. So that's why they can bring in private counsel, and oftentimes do. But in rare circumstances, if your court feels like this is a righteous de facto parent who just can't seem to afford private counsel on their own and they want to appoint you, you are going to have to accept that appointment and be prepared to proceed accordingly. And then they have the right to present evidence, as noted already. Now, we mentioned Matthew P., and we're going to keep talking about it, and on one of our later slides, we'll go into more detail about the actual facts and differentiating circumstances of that case, but we've put some information here. There is a quote from Matthew P. that says that de facto parents should be entitled to the same procedural rights as a natural parent. Now, as parents counsel, if we're adverse to it, we hate that statement, because that's like, whoa, wait, what? But if you're a de facto parent and you're trying to argue for more extensive procedural due process rights, this might be where you hinge your argument. This might be where you try and analogize to the facts of this case and to the issues and interests that are at stake for your client de facto parent. I think we pretty much went over all the rest of those rules and procedural rights that parents have. I think Jason extensively went through those. So substantive due process rights. There's some significant differences between substantive due process rights that parents have versus those that de facto parents might feel that they have. Basically what the case law says is that they don't have any substantive due process rights, with some somewhat exceptions that aren't really grounded in their constitutional rights to care, custody, and control of a child, because they don't have that. They're not a parent. They are this like construct that's sort of like a parent, but doesn't give them those same constitutionally protected rights to the care, custody, and control of a child. Which means they have no right to reunification services. There's a caveat here, though, that does say that as a matter of practice, some courts may want to provide them with reunification services, but if they do, that de facto parent lacks standing to challenge the adequacy of it. This Clifford S. case, just so you know factually speaking how that came about, the de facto parent in that case was like stepfather, boyfriend or stepfather. I don't know if they were actually married and it was stepfather, but he was in the home with mom who was receiving reunification services, and so the court wanted to order services for this de facto parent as well because it was going to be in the best interest of the child to hopefully achieve some sort of reunification for this family. However, when those services proved inadequate or unreasonable, there's no reasonable services argument there. There's no remedy. So it's sort of like enhancement services. It's like a farce, but they can do it. No right to custody or continued placement, and no right to visitation. But you should know if you represent de facto parents, while there's no right, you can argue under 362.4 that they can issue a visitation order upon the issuance of a custody order for your clients that provides for their continued contact with the child after the case closes. And they may petition through a 388 for contact. And then y'all know what parents' rights are, so those are there.
And I'm sorry, guys, I think we were missing the past two slides, so just make sure you signed in and we'll email out the full slides to everyone.
Sure. So this is a quote that is very meaningful and I think we should all be aware of. So it's from Rita L, and it basically says that the court may not consider the quality of the relationship between a child and the de facto parent in deciding whether or not to terminate a parent's reunification services. That while that relationship may be legally relevant at a 2-6 hearing, the court's focus at a status review hearing is whether the parents met the reunification requirements. The de facto parent's relationship with the child does not have any independent relevance. Neither do they have the right to contest or grant a parent with visitation or services. So really important because, you know, one, the fact that the child has been with the de facto parent obviously isn't relevant to whether or not there's a risk to return and shouldn't be considered and we should be objecting to any evidence of that even coming in. In addition, you know, if the de facto parent wants to try to participate in one of these proceedings, we may be able to argue that the burden is on the county in determining whether or not there's a risk. The de facto parent there shouldn't be an additional hurdle that the parent needs to overcome that now the de facto parent gets to come in and somehow demonstrate some sort of risk. So we may be able to try to preclude the de facto parents from really participating in these status review hearings. One, by saying the courts have already determined that the relationship is irrelevant, and two, Section 2.2 talks about the burden being on the county, and that if the de facto parent wants to participate, they can provide some information unique. They can do that sort of with their relative information form or something like that, but that it's really not. It's an unfair burden and hurdle for the parent to try to have to overcome not only the county's burden, but also the de facto parent trying to come in and demonstrating additional sense of risk. I'm going to go a slide.
Oh, yeah, this is just here for your information. It's not going to be as applicable, but we just wanted you to know that the rights to appeal. So these are some of the differences between rights to appeal, and some of them are pretty relevant. Important thing to note is what's highlighted at the top there in the header, that interests must be injuriously affected or prejudiced. That goes for parents or de facto parents, your right to appeal. You have to have an interest that's prejudiced or affected. What that means, unfortunately, for parents is that we know we have a general right to appeal all orders in the juvenile court, and you have your writ issues that is not part of this training that you should be aware of. However, case law says that there is no right to appeal the denial of de facto parent status for a relative. So if you were in favor of it and you were joining and you tried to then appeal that, you're not going to have standing. That might likewise translate into no right to appeal the grant, because it's unclear how somebody just being able to present information to the court would injuriously affect your client. But I didn't see any case law right on that point particularly.
Is that only for a relative or for anyone?
Well, that case said for a relative.
I see.
However, the Crystal J case said that even the child themselves, you would think maybe their rights are somewhat affected by it, right? Because they're the one who this person is asserting interests on behalf of. Even that child has no right to appeal the denial of de facto parent status to an individual. And that person, I think, was just a NERFM in that case, like a family friend, or like, might have been, I think it might have been like a school, like a mentor type person who they wanted status for. So just be aware of that. De facto parents also have a very much limited right to appeal. So if you're representing de facto parents, you're really only going to have the right to appeal the denial of the motion for status if that happens. But if the motion for status gets denied, then we never get appointed. So that wouldn't be something we would have to file. If they are appointed, the denial of a 388 petition that was filed by your clients, or a Section 387 petition that was for removal from your client, because that's something that could definitely affect their rights going forward. To answer Donna's question, discovery. So 827 is very specific. And we talked about, when Jason mentioned earlier, about the very specific rules and rights to inspection and receipt of documents that parents have. De facto parents do not have that. They have no automatic right to inspection. They don't have pre-hearing discovery rights. The 5.546 pre-hearing discovery specifically notes with respect to parents and children. They must file an 827 for disclosure. What that means for us as counsel representing de facto parents is if that status gets granted and you're appointed on the case, you better start thinking about filing an 827 motion to maybe get some information so that you can adequately represent or protect your client's interests. Now you're going to have to tailor that request to what's necessary for the issue at hand. So if it's a 387, you're going to want a copy of the detention report, I'm sure, and the jurisdiction report. But you're probably not going to get past review hearing reports, or and they might redact some of the information from that. And those are arguments and objections you can make as parents' counsel. Do you have more to add?
I have a question.
Yeah.
But the de facto parents are, once it's granted, say there's a review hearing, their attorneys are often provided copies of the status review reports. Is that something we should be objecting to?
So, yes. So, and that's the point, is that, from a parent's side, if you want to restrict them from having certain information, or you can object to the release of that information, because by being granted de facto parent status or doesn't mean that the person is entitled to all of the records in the case. The records must be necessary and have substantial relevance to the needs of that person that is seeking the documents, the de facto parent.
Which is interesting.
And so we can argue that it infringes on the parent's right to confidentiality, and that you can argue that they're entitled to no more information than is absolutely necessary to protect that person's interest in the child.
So oftentimes, just going off of what was said, they just place the report in the basket. We don't even know like Frank Ostroff has been appointed counsel for a lot of these cases that I've had de facto parents on. And he just gets a report, we don't even know about it, it's just in the basket.
Should we walk it on as soon as the de facto parent status is granted? Or not even walk it on, but as soon as they're granted that status, make a record and state, Your Honor, we're objecting, at this point we're objecting to any reports being provided to the de facto parent or counsel, and we would ask that an 827 be filed so that we can respond appropriately.
Sure.
I would say that would be my suggestion, and just so, I have several objections to 827s that I've filed, and I mean, the request needs to be specific, particularized, so objections you can make are on vague or overbroad, and it shouldn't be like once it's granted as to this thing that they get unlimited access to every future document. So that's not what it's supposed to be. And you know, depending on your courtroom, I was in a courtroom where that was happening. I had conversation with the county counsel and the court officers, and they stopped doing that without the court's permission to release the documents. So I mean, you know, depend on your courtroom, know your personnel, but definitely make your record. And if you know that something's been released to them that was in without a proper 827, you can ask on the record, you know, it's my understanding that counsel has obtained a copy of the report. There's no 827. I'd ask that that report be returned and that an 827 be filed, as they're not entitled to inspect that or have that information in the interest of the confidentiality of these proceedings.
So presenting documentary evidence. From a parent's side, we have INRAE-BF, which we can argue that the de facto parent role should be informational, not adversarial. That we can argue that the de facto parent should be limited to providing information through a caregiver information form or a 388 petition. And this is the argument that I was trying to reference in regards to status review hearings, is that, you know, we may be successful in arguing that de facto parents have no legal interest, no legal right to continued custody of the child, and therefore have no direct interest on being heard on whether or not a parent should reunify with the child. That the burden of proof showing of detriment is on the worker and not on the de facto parent, and that if the social worker fails to meet the burden, the only other party with a right to present proof on the issue is the minor's attorney. So just something to think about if you get into these really contested status review hearings where the de facto parent wants to try to provide a whole bunch of information that would be adverse to the parent.
And just so you know, just for a little tidbit of information, this BF case involved a de facto parent seeking the 730 eval done for a parent, and that was something that they had no interest or need for that information. So that's where this quote comes from in the context of that request. And they had sought it by way of an 827 even. This is the comparison that we talked about earlier, the two cases, Matthew P. versus Damien B. with regards to witness testimony. The difference being, in Matthew P., if you're gonna, you know, you would be citing that case for, yes, de facto parents can always call witnesses, but if you're distinguishing as parents' counsel, this involved a 388 petition that was filed by the de facto parents. So they were the moving parties. They were the person with the burden. So then report was submitted by the social worker, as often is, that put all sorts of hearsay information in it and contested all the information in their 388. And they were only allowed to submit their caregiver information forms that were attached to their 388, but not given an opportunity to address the conflicting information that brought up factual and credibility disputes that they had the burden to establish. So the court said, yes, they can cross-examine the social worker. They do have that right. Because they were shut out of the process. There was no mechanism for them to then provide the day of caregiver information sheets to address that information that was provided by the social worker. In Damien B, way different. And also, in that case, very strange to note that the de facto parents actually stood alone in their position. The court let de facto parents, in this case, set a contest on a 2-2, where the recommendation from DCFS was to return to mom. Minor's counsel was in agreement with return, and mother obviously was in agreement with return. Nonetheless, the court said, sure, let's have a contest and hear what you have to say, which is really bad law for us as parents, but you're a de facto parent, cite to that. They said in that case, though, no right to cross-examine the social worker. I'll let you put on your contest, you can submit your caregiver information forms, but you're not shut out of the process. They got to give their information to the court. There was a long diatribe back and forth between the court as to why do you need to cross-examine this social worker? They basically just wanted to make it super salient, all this information that was already before the court. And the court's like, this is cumulative, duplicative. It's in the reports. I don't need you to do this. There were no issues of factual dispute in this case, so that's important to note. And then finally, I know we're like out of time, right? Almost. Termination of de facto parent status. It requires a 388 petition, a 388 motion pursuant to WIC 388. And just so you know, case law says that once it's granted, it ends only when dependency is terminated or there's a change in circumstances. So just because a child goes home doesn't mean that that de facto parent status ends. So that person may continue to participate in the proceedings. When you're going to want to make sure that if you're successful in getting your client's child back in the face of a de facto parent opposition, don't forget that 388 to terminate the status when there's been a sufficient change and they no longer have that unique, relevant information or psychological bond. Maybe they're no longer having any visits or contact. Let a sufficient period of time pass and file your motion to terminate. Because loss of custody alone doesn't render it a non-issue. There needs to be that actual change in circumstances and best interest. I will say the one case that I had, my save Lexi just really quickly, it was so hard to get de facto parent status terminated in that case, and it only happened after they started going to the media, sharing all her information, and so we said that they were contravening the role of a parent, which is what gave them the status in the first place. They're acting against her interests, and that was what allowed us to get that terminated. But even under those circumstances, it was really difficult. So just know it's kind of hard. Any questions? Yeah.